The question hangs in the air, heavy with implication. You see the flash of red and blue in your rear view. Pull over with that familiar sinking feeling and go through the routine. License, registration, insurance. Then, the officer leans down and with a tone that's either casually conversational or pointedly suspicious, asks it, "Have you been drinking tonight?" Your heart skips a beat. Your mind races. Maybe you had one beer with dinner 2 hours ago. Maybe you had nothing at all, but are nervous, and nervousness can look like guilt. Maybe you had several, and now a wave of panic threatens to overwhelm you. This moment, this single question, is the pivot point. Your answer here doesn't just determine the next few minutes. It can determine the next few years of your life. It can be the difference between a warning and a handcuff, between driving home and being booked into a jail cell, between a clean record and a DUI conviction that follows you for a decade. This is not a simple inquiry. This is a legal trap, meticulously designed and perfectly positioned. The officer isn't just making conversation. They are conducting an investigation, and their very first, most powerful tool is this question. It is a probe for a confession, however small. Any admission, just one, a glass of wine, earlier, but not in hours, is not received as an honest disclosure. It is received as probable cause. It is the key that unlocks the next phase. The request to step out of the vehicle, the field sobriety tests, the preliminary breath test. It transforms you from a driver in a routine stop to a DUI suspect. So what do? The social instinct is to be polite, to explain, to cooperate. The fearful instinct is to lie. The legal reality, the one every defense attorney knows and wishes every client understood before that fateful night, is entirely different. You're under no legal obligation to answer that question. The Fifth Amendment to the United States Constitution protects you from being compelled to be a witness against yourself. You have the right to remain silent. But here's the practical truth that law school doesn't always teach. Remaining silent is a right, but exercising it is a skill. Deafening silence can be construed as defiance, as guilt, as non-cooperation. It can anger an officer and escalate the situation. The magic lies not in what you say, but in how you say it. The goal is not to be combative, but to be strategically protective. You must navigate a path that safeguards your constitutional rights without providing the officer with the very evidence they need to deepen their investigation against you. Let's dismantle the psychology of the encounter. The officer is trained in the standardized field sobriety test, SFST curriculum, which includes the pre-stop observation, the personal contact interview, and the all-important initial questioning. The "have you been drinking?" question is a cornerstone. They are listening not just for the content, but for everything around it. The hesitation in your voice, the slurring of words, the over-explanation, the smell that might waft out when you speak. They are looking for your eyes in the beam of their flashlight, watching for slow, lethargic movement as you retrieve your documents. Every element is a data point. Your job is to stop the data collection before it escalates. Therefore, the optimal response is not an answer to the question at all. It is a polite, calm, and firm deflection that asserts your rights while maintaining respect for the officer's duty. You are not refusing to cooperate. You are choosing how you will cooperate on terms the Constitution grants you. A model response is, "Officer, I respect that you're doing your job, but on the advice of my attorney, I don't answer questions. I am happy to provide my license, registration, and proof of insurance." Let's break down why this works. First, it is unequivocally polite. You are acknowledging their role. Second, it invokes a higher authority, "on the advice of my attorney," which depersonalizes the refusal. It's not you being difficult. It's you following professional legal counsel, something an officer understands. Third, it clearly and directly invokes your right to not answer questions. Fourth, it immediately offers compliant, lawful cooperation by providing the documents you are legally required to provide. You are drawing a bright line. You will fulfill your legal duties, but you will not participate in your own potential incrimination. What happens next is critical. The officer will likely press. They may say, "Why won't you answer? If you haven't been drinking, you have nothing to hide." This is a classic interrogation technique. designed to provoke you into breaking your own resolve. Your response must remain a calm, respectful, and unbroken record. I'm just exercising my rights, sir/ma'am. I don't answer questions. Do not explain. Do not justify. Do not engage in a debate about rights. Broken record politeness is your shield. Now, let's address the scenarios. Perhaps you truly have had nothing to drink. Your instinct screams, just say no. I have nothing to worry about. This is the most dangerous instinct of all. By answering no, you have now made a statement. If the officer, based on any other subjective observation, bloodshot eyes, nervousness, a slight imbalance, decides to administer tests and you perform poorly, and tests are designed to be difficult, even for sober people, your no can be used against you as evidence of deception or guilt. You have painted yourself into a corner. Your prior statement can undermine your entire defense. Perhaps you have been drinking, but believe you are under the limit. This is irrelevant. Field sobriety tests are not calibrated to 0.08%. They are calibrated to detect impairment, and impairment is subjective. By admitting to any alcohol, you have just handed the officer all the probable cause they need to proceed with every test at their disposal. You have done their job for them. The legal landscape surrounding DUI stops is a minefield of technicalities where procedure is everything. The initial stop itself must be valid. A traffic violation, equipment failure, or reasonable suspicion of impaired driving. The officer's observations form the basis for the next step, the request to exit the vehicle. This request is almost always lawful if the officer has any reasonable suspicion. Once you're out of the car, the officer will likely attempt the 3 standardized field sobriety tests: the horizontal gaze nystagmus, HGN or eye test, the walk and turn, and the one-leg stand. It is vital to understand, you have the absolute right to refuse these tests. In most states, refusing these preliminary field tests carries no direct administrative penalty like license suspension. The officer may arrest you based on their other observations, but you have denied them a treasure trove of evidence. These tests are difficult under the best of circumstances, performed on the uneven shoulder of a road, in traffic with flashing lights, under extreme stress. They are, for all intents and purposes, designed for you to fail. Politely declining them is often the single most effective act of self-defense in a DUI stop. A simple, "Officer, I do not wish to perform any field sobriety tests," suffices. The dynamic changes dramatically with the preliminary breath test, PBT, the small, handheld device often offered at the roadside. This is a trickier point. In many jurisdictions, refusing the PBT can result in an immediate administrative license suspension separate from any later DUI charge. The laws vary drastically by state. However, the PBT result is often inadmissible as evidence of your specific blood alcohol content at trial. It is used primarily to establish probable cause for an arrest. This is a strategic decision point with real consequences, and the right choice depends heavily on your state's laws and the specific circumstances. If the officer establishes probable cause through your admission, their observations, or your performance on field tests you chose to take, you will be placed under arrest for DUI. This is a critical juncture. You will be read your Miranda rights. You will be transported. Your car may be impounded. The most important thing you could do now is to stop talking entirely. Do not make small talk in the patrol car. Do not apologize. Do not try to explain. Do not ask, "What's going to happen to me?" Anything you say will be recorded and used against you. Your only statements should be a repetition of your desire to speak with an attorney and your invocation of your right to remain silent. At the station, you will be asked to submit to a chemical test, a breath test on a larger evidentiary machine like the intoxilizer, or a blood draw. This is governed by implied consent laws. By virtue of having a driver's license in your state, you have already consented to take this test if lawfully arrested for DUI. Refusing this evidentiary test carries severe, automatic, and non-negotiable penalties, typically a long-term driver's license suspension, often 1 year or more, regardless of the outcome of the criminal case. In many jurisdictions, the prosecution can also use your refusal against you at trial, implying consciousness of guilt. This creates the ultimate legal paradox of a DUI stop. You have the right to refuse the early, subjective tests, questions, field sobriety, to protect yourself, but refusing the final, objective chemical test after arrest triggers automatic, harsh punishments. The general legal advice is stark. If you're arrested for DUI, you should almost always submit to the official chemical test. The administrative penalties for refusal are frequently worse than the potential penalties for a first-time DUI conviction, and a test result provides concrete data that a skilled defense attorney can often challenge on procedural grounds. The aftermath is where the real battle begins. A DUI arrest is not a conviction. It is an accusation. Every single step we've just outlined is ripe for legal challenge. A defense attorney will dissect the initial stop. Was there valid probable cause? They will scrutinize the officer's report and any dash/body cam footage. Did the officer properly administer the tests? Did they have reasonable suspicion to expand the stop? Did they correctly advise you of implied consent? Was the breathalyzer machine properly calibrated? Was the blood draw performed according to protocol? The chain of custody of evidence is a fragile thing. The law is a maze of procedures, and an error by the state at any point can lead to suppressed evidence or a dismissed case. This is not about encouraging impaired driving. It is about understanding power, procedure, and protection within a system where the stakes are catastrophically high. The "have you been drinking?" question is the gateway. Your response sets the tone for everything that follows. By choosing not to answer, by politely asserting your right to not provide evidence against yourself, you retain control. You force the state to build its case around you, not with you. You give your future attorney the strongest possible foundation for your defense. You transform from a subject of an interrogation into a holder of rights. The road is not just asphalt and signs. It is a jurisdiction where your liberty can be negotiated away in a conversation. Knowing how to navigate that conversation isn't about guilt or innocence. It's about understanding that in that moment, under those flashing lights, you're not just a driver. You are a citizen with rights, and the most important thing you can do is to be silent, be polite, and be smart. A question for your reflection. Given the severe automatic penalties for refusing a post-arrest chemical test, but the strategic advantage of refusing earlier field tests, where do you believe the line should be drawn for a citizen trying to protect their rights during a DUI stop? Is the current balance between police investigatory power and individual constitutional protection a fair one? I'd be very interested to hear your perspective in the comments below.